This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
All right, now please allow me to present our final speakers, Jeanne Behling, Sanford Jossen, and Steve Sepassi, who will conclude our MCLE Day presenting a 2-hour ethics program on navigating ethical waters, a dive into legal ethics and mediation. Jeanne Behling is a seasoned mediator, having successfully resolved hundreds of disputes since commencing her full-time mediation practice in 2016. She commands an impressive background as an attorney representing plaintiffs and defendants alike for over 2 decades, specializing in personal injury, product liability, sexual abuse, harassment, and employment litigation. Her experience also extends to subrogation and cases involving peace officers and government claims. For decades, Ms. Behling has passionately delved into mediation theory and practiced it throughout her career. Her global experiences include nearly 5 years spent in Singapore, have instilled in her a profound appreciation for diverse cultures, making her an empathetic mediator who genuinely cares for people and their unique perspectives. With her exceptional ability to connect and relate to participants, Ms. Behling is an invaluable asset to any mediation. Next, for over 41 years, Sanford Jossen has been a key figure in alternative dispute resolution. Since 1987, he has mediated or arbitrated thousands of cases across a wide variety of civil litigation matters. With a wealth of experience in handling delicate cases and challenging clients, Mr. Jossen has demonstrated his ability to navigate highly sensitive matters with a unique blend of professionalism and empathy. He has a successful track record of mediating highly sensitive personal injury and civil cases, making him a go-to mediator in the industry. Mr. Jossen conducts his cases with compassion and a commitment to fair and equitable outcomes for all litigants. He understands the complex emotions involved in legal disputes and values the opportunity for all parties to have their voices heard. His patience, responsiveness, and accommodation ensure that all parties have a safe and respectful environment to express the manner in which their disputes have affected them. Lastly, with over 25 years of experience as a skilled litigator, Stephen Sepassi is a highly accomplished professional in handling a wide range of legal matters, including personal injury, school liability, real estate, landlord-tenant, commercial, and insurance cases. Known for his unwavering tenacity and civility, he consistently demonstrates a fair and respectful approach to mediating and resolving disputes, reflecting his successful tenure in private practice. Throughout his illustrious career, Mr. Sepassi has skillfully handled an array of cases ranging from small, personally impactful cases to large multi-million-dollar disputes, including vehicle accidents, product liability, catastrophic injuries, and wrongful death. In addition to his extensive legal experience, Mr. Sepassi brings a deep understanding of business and partnership issues and diverse life experiences that allow him to connect with the disputing parties and find common ground in his mediation practice. He positions himself as the village elder between the disputants, a position that both sides of the bar have come to appreciate and respect. Presenters, the floor is yours.
Well, thank you, Hayward. I think we are going to be looking at the slides here today. Obviously, we've been introduced, and thank you both to Hayward, Sanford, and Steve. The agenda, we are talking about 8.3, and there's quite a few slides on this particular new reporting requirement because a lot of people are really interested in what does it mean, when do I have to report, so we'll get into that. We're going to be talking about mediation confidentiality, ethics in mediation for lawyers and mediators, procedural fairness versus outcome fairness, and competence. And we will be looking at the question and answer feature but we may not be able to answer all of the questions during the presentation. I do want to go ahead and get started on 8.3 if we can move to the next slide. So this is a new requirement. It's a new rule of professional responsibility. It went into effect August 1st of 2023. In March of 2023, there was the 45-day period where people could respond and make comments. And there have been, I noted that there's been 2 attempts to pass the 8.3 since 2010, but there's been many attempts to pass 8.3. I think you'll be interested to know that the state of California is the last state to adopt some version of 8.3, and I find it interesting that Kentucky was the second to last, and they adopted it in 1990. So for 33 years, we have been the only state without some version of 8.3. I was told by persons at the state bar before it went into effect that we're closest to the Illinois version of 8.3, but our 8.3 has a couple of wrinkles in it that no other state has, and we'll see, how that develops. It's still relatively new. So next slide. So the state bar has provided some of these slides because the state bar wants to make sure everybody understands 8.3. And the state bar has provided a couple of hypotheticals and wants me to make sure that I tell you that these are not legal opinions. These are just hypotheticals. But the reasons for 8.3 is it's a rule to maintain the integrity of the profession and protect the public. All of us know what's been going on in the media and some of the really horrendous cases that have been reported and some of the violations of attorneys' trust accounts. And so certainly that is relevant and impacts when this particular rule came into effect. I mentioned that in March of 2023, there was a period of 45 days that persons could make comments, and there were only 390 comments to this potential rule. 328 came from attorneys, so that's 84%. And of the comments, 51% said, we don't need this rule. And that really didn't affect the bar, apparently, because the rule obviously went into effect. I have here on this slide, and I realize that it's actually a tiny bit behind. In October of 2023, the SB 40 actually became law, and it's now a new, I will find it before the end of the presentation, but it's 6908 of the Business and Professions Code. I want to say 6908.8, but I'll have to double check that. And the SB 40 was enacted, and it also tells us as attorneys that we need to report if another attorney is committing treason. So it's above and beyond 8.3. It's really uncharted waters, and that pun was intended with the navigating the waters here today. Next slide. So the reporting obligations are when you have to report, when you may report, and when you're prohibited from reporting. So there are certain times when you are required to report, and we'll go through that language pretty specifically. And then there's certain times when you may report. And then there are certain situations such as when you learn of information when you're being retained as counsel and you learn of information, and then you are not allowed to report. So next slide. So the requirements, which I think most people are really most interested in, are attorneys are required to report the following types of misconduct of other attorneys: criminal acts, conduct involving dishonesty, fraud, deceit, misrepresentation, misappropriation of funds or property, and the misconduct has to raise a substantial question. as to the attorney's honesty, trustworthiness, or fitness as an attorney in other respects. I know I'm reading this slide, but it's a lot of information. The whole idea of criminal acts is covered in another slide, but the Rule 8.3 doesn't specifically say what criminal acts are covered. The State Bar actually sends us to Rule 8.4, and again, there's a slide on this, so we can talk about it when we get to that slide. But conduct involving dishonesty, fraud, deceit, misrepresentation, there's some hypotheticals that we'll have that will help a little bit, but this is all of the behavior that the State Bar, I think, has focused on and has indicated that, you know, the public looks to us as holding a higher standard. And so certainly when there's conduct of dishonesty, fraud, deceit, and again, one of the slides will we'll talk a little bit more about what that all includes. So next slide. So this hypothetical, and I'm not going to read the whole thing because you can read it. Partners in a law firm, they have a trust account. When one partner is looking at the monthly reconciliation, they notice that there's a deposit that is not related to a case. And then they notice that of this deposit, let's say it's $1,000 deposit, that the items that were paid exceed the deposit by $50. So the partner who notices this confronts the other partner about using the client trust account. And the other partner has an explanation. The explanation is that his wife has access to all of their personal accounts and she's got a gambling problem. And so this is the only way that he can safely pay his family bills. So if you are Anne, do you have to report Richard? Sanford, Steve, you want to chime in for me?
You know, that is a very good question. This new rule is obviously going to have you know, a ripple effect in our practice. You know, basically, if she reports that, obviously that's pretty much the end of the partnership, in my opinion. Could it be perhaps that, you know, Anne could convince Richard to come clean with the State Bar and say, I made a mistake, this is what has happened, and we're going to rectify it? I don't know. What is a good answer? I don't know if, like anything else in the law, I don't think there's a black and white answer, but I may be wrong here.
Well, the State Bar recommends that this situation be reported. They considered this a situation where there's misappropriation. Just even though it was the $50 in expenses being paid, that was more than what the attorney put in. Also commingling, which is Rule 1.15. This is also commingling, and it's it raises, we talked about, or I mentioned, there's a whole list of, you know, dishonesty and the list of when you have to report. And on the bottom, it says, if it raises a substantial question. Well, this is what the State Bar would consider a substantial question as to Richard's honesty, trustworthiness, and fitness as a lawyer. And additionally, there's also, when you go to report, you have to evaluate your knowledge. Do you know that something actually happened? And because there's a trail here and you can see the deposits going in and the money going out, Anne can legitimately say she knows something happened. She then talked to Richard, so she confirmed that something happened. So the State Bar would say that this is an instance where somebody would have to report. And the next slide gives us some of that 8.3a and the Rule 115, and then also the Business and Profession Code, the 6106, are all relevant here. So the next slide talks about what I had mentioned, that there's no definition in 8.3 itself. Sorry, the next slide talks about 8.4. And that's where we find the definition of a criminal act. And so when you're trying to decide, okay, did a criminal act happen that you have sufficient knowledge about that you then have to report, we don't have any direction in 8.4. So the state bar refers us to, sorry, in 8.3, the new, what some people have called the snitch rule. We don't have any direction in 8.3. And so the state bar references 8.4. And it says that crimes that are a criminal act are crimes establishing moral turpitude, crimes involving, I don't know, that's not mine. Sorry. Crimes involving mishandling of entrusted funds. And I thought this one was interesting because we all know about trust accounts, but in 8.4, criminal act also includes the use of, or basically being behind on payroll taxes or unemployment insurance contributions. Criminal conduct such as multiple drunk driving convictions, substance abuse accompanied by harm or potential harm to others, violent crimes, and then where the attorney's behavior evidences a lack of respect for the legal system and an alcohol abuse problem. So some of these are kind of, as Steve had said, you know, where do we go, and what does this all constitute? Some of these, although when you read it, you think you might know what it means, some of these will cause us to, you know, consider, was there in fact a criminal act? And do I have sufficient knowledge that I know that I have to report? We'll get to it later, but the language of the section 8.3 also includes that it has to be done with undue delay. And so we'll talk about that. So there's a lot of obligations in 8.3 to report, what to report, how much knowledge you need, and that how quickly you have to report it. So moving on. So when they talk about, or when the language is used in the code of substantial question, the language is defined as a material matter of clear and weighty importance. But it's also defined in the Rule 4 of 8.3. I said rule, but 8.3 itself has 10 different comments, and the 10 comments are really important. The 10 comments came out before 8.3 went into effect, and the comments are really intended to try and help us as lawyers navigate and work through when do we have to report. And comment 4 defines substantial question as the seriousness of the possible offense and not the amount of evidence of which the lawyer is aware. We've also looked to other jurisdictions, and the Oregon State Bar has an opinion on this where they talk about merely technical violations of the conflict of interest rules would not qualify, whereas destruction of evidence, suborning perjury, or self-dealing with trust funds assuredly would. So this is one of the times where, you know, as we do in our daily practice, if we can't find the necessary information in California case law or in California in the legislative information, that we go to other jurisdictions. And so we've looked at Oregon, and Oregon gives us a little bit of, you know, this is when it applies versus this is when it doesn't apply, for a little bit of help. Next slide. So when do we not have to report? And what are the limits on mandatory reporting? So this is actually, this slide seems to have a ton of information, but it's really, it's really pretty easy to break it down. I mean, the limits on reporting are when it's privileged or confidential, when you're in a consultation with another lawyer, when you're working on an ethics hotline or a similar service, when you're volunteering your time, or when you learn of information through a substance abuse program or through, I think it's called the lawyers, the
other bar.
yeah, lawyer assistance program. I knew it was LAP. I was going to say it LAD, lab, but it's LAP, the lawyer assistant program. And a lot of us know it as the other bar. It's codified in Business and Professions Code 6234 as to when you've learned information in those programs and you can't divulge that information. So privileged and confidential information, that's basically when you are using client information. You have a duty to maintain the confidentiality of client information. So that becomes something you have to consider. That's the 6068E. Rule 1.6 is of the state bar rules when it's confidential information of a client as well. And then Rule 182 is use of a current client information. Talks about you can't use the client's information to their disadvantage. Those of us who are mediators, who the panel all are mediators, I think we're happy to learn that mediation confidentiality is not abrogated here, that it's given its importance. And so if something is learned during mediation, that is not something that a lawyer has to or can even divulge. And of course, attorney-client privilege, it talks about other applicable privileges. The only ones I could think of would be like spousal privileges or, you know, might be doctor-patient privilege, and then other rules and laws. So that one's the biggest one. Consultations with other lawyers. There is, I mentioned the 10 comments that were provided by the State Bar. The second comment is that the duty to report under 8.3 is not intended to discourage lawyers from seeking counsel. So if lawyers think they've done something wrong and they want to seek an attorney's advice, that consultation needs to be held privately and is not then the subject of something where the lawyer has to report. So ethics hotlines, I think that's a very small portion of what you might cover. And then, of course, the whole situation with the LAP, Lawyer Assistance Program, that is all confidential as well. So these are exceptions or limits on mandatory reporting. So next slide. So here's a hypothetical where we have two attorneys. One attorney hires another to consult for advice about his ethical duties under 8.3. And he explains that he's in one of these lawyer assistance programs, and he has learned that another lawyer has been arrested for DUI, and he's already been convicted of DUI 3 times. And so the question is, does Todd, the lawyer who learns about it in the lawyer assistance program, does he have to report? And does Sandra have to report? And I didn't let Sandy and Steve read these before I threw them out at them. But what do you guys think? Does Todd have to report? Does Sandra have to report?
I don't think Todd has to report because he learned this information through a lawyer assistance program or mental health or alcohol abuse or substance abuse program. So he doesn't have to report.
Exactly. What about Sandra?
I don't think she should either because she's being consulted for this very issue. So I thought one of the exceptions was that, you know, when you do that, you don't need to report.
Exactly. You guys were listening. I really appreciate it. So exactly. Right on point.
I'd like to ask a question about a different hypothetical, but I don't want to interrupt the flow. So you tell me.
I can try.
Okay. This might be a practical scenario for people that are listening. Two lawyers in a firm share a secretary. Okay. Secretary tells one of the lawyers that the other lawyer is sexually harassing her.
Wow.
Does lawyer that's given this information have a duty to report? And does the sexual harassment constitute moral turpitude? What do you do? I mean, obviously, in the first hypothetical that we talked about with the attorney-client trust account and the wife, that involves money. And it seems to me that in any situation involving money and and a trust account, probably one would have to report, even if it's a corrosive to a partnership or a business relationship. But what about this situation? It's a lot more gray.
Well, I think then you go back to the term substantial question. So the seriousness of the possible offense, I think you'd need some information on the sexual harassment. And then I think you would need to have, I mean, do you believe the secretary? Is there a potential that the secretary is, upset with the other partner? Lots of things that I think you would need to look into before you automatically report.
Very tough. The reason I bring it up is not for a black and white answer, but just to show how difficult it can be in certain circumstances as a practical matter to comply with this rule. And the other question I have is, and perhaps you'll address it at the end or at some point, what happens if you know and don't report?
Then you can actually be
In violation.
in violation of 8.3, and you can potentially be brought before the state bar under 8.3 because you did not report.
Because this is information we all need to know as attorneys.
Right.
Thank you.
So, sorry, Sandy. So we just got the answer for what Sandy and Steve already provided to us, that the only thing that this slide does tell us is the little bit of information that the multiple convictions for DUI raises substantial question as to the fitness to practice. And there's the case site, which is quite old. And so that's pretty well established here in California. So next slide, I want to get to a couple more slides here. So the attorney may report any other violation of the rules of professional conduct and or the State Bar Act. So that's the may. There's not a lot on this particular may because it's hard enough to figure out when you have to report. But you need to, if you're considering reporting something that is a violation of the rules of professional conduct, you aren't necessarily talking about a criminal act, so you need to consider the seriousness of the lawyer's offense and the potential implications on the public and the profession. You also have to consider, the lawyer's clients too. So it is a, it's a pretty weighty proposition to make a report. You're really supposed to really think it through and know, absolutely know before you report. So there's a few more slides here on 8.3, and then we'll be moving on a bit. So you have to know of credible evidence and you have to report without undue delay. Now, the problem with saying that you have to report without undue delay is the comments also mention that you don't want to cause material prejudice or damage to the interests of the client of the lawyer or client of the lawyer's firm. So here we are, we're told that, first of all, we have to know, but once we know, we have to do it without undue delay, but we got to be careful about not affecting the client or even the client of the lawyer's firm. So it's a bit of, I mean, it's I wanted to say a quagmire, but I was also thinking of the sinking sand, you're stepping into the sand and you're just sinking. So next slide. So here's the definitions here. Knows is actual knowledge. Knowledge may be inferred from the circumstances. And what has been determined as credible evidence. And I think I started my career in the DA's office, and this very first one, eyewitness descriptions. Those of us who had those eyewitness descriptions might dispute whether that's credible evidence, but any records, admissions of the attorney, obviously that's all credible evidence. So if you have the credible evidence, the Anne situation with the Richard, where she had the documentation plus she had her partner telling her, that's credible evidence. So next slide. So here's one that has put a lot of, I don't know about fear, but a lot of concern that I have heard raised. Is it retroactive? So the duty went into effect on August 1st, 2023. So presumably, you don't have to report before August 1st, 2023. But what if you know of conduct that occurred before August 1st, and especially if that conduct is either still occurring or still has effects, do you have to report? And the answer is yes. So there is a certain, I mean, it's sort of like pseudo retroactivity, right? And I do love that this slide has a beautiful picture in the background, but it's not a beautiful picture in the background necessarily if you have to report something that even happened before August 1st of 2023. Okay, next one.
So if I can just ask you a question here, because I think it's also in the Q&A. That's very interesting, because somebody's asking, what about the statute of limitations on something? So for example, if somebody has evidence that an attorney suborned perjury, but this was 8 years ago, what do you do with that?
Well, let's see.
Is there statute of limitations on suborning perjury?
I don't know. I don't know off the
Yeah.
top of my head.
Yeah, with a new rule like this, there's going to be so many questions that need to be resolved eventually.
especially in light of the holding in Ray Himmel,
right.
which
And
is
that's
in front of us right now.
Yeah, that's the one I was going to get to. So in Ray Himmel, and it's an old case, and I believe it's an Illinois case. It's an Illinois case. From what I have been able to research, this is the only case where there was only case in the United States where there was a prosecution under 8.3 exclusively. In other words, the other prosecutions that mention 8.3, there might also be a prosecution of a violation of a trust account, and also 8.3. So in Ray Himmel, as far as I could find, and if I'm wrong, please, the audience will let me know, but is the only case where the attorney said that they didn't have to report because the bar was already aware of the situation. So knowing that, and knowing that even if there's multiple complaints already, that you still have your own obligation to report, I think I would say the safest conduct would be to report that suborning of perjury. I reread the comment on, conduct before August 1st, and it says the attorney must report the conduct to the state bar or to a tribunal to satisfy their own ethical obligations. So you're not necessarily reporting because of the other attorney doing something wrong right now. You're reporting because of your own ethical obligation, which is, as I said, this is quite a high bar. Did that answer your question, Steve? Sort of?
Sort of, but let me just be clear about in Ray Himmel. So in Ray Himmel, they said that even though the client had reported the other attorney, this other attorney still had a duty to report. Is that what the opinion was? Okay.
Yeah. Yeah, in Ray Himmel's a little interesting. There's a lot of facts that aren't part of this little blurb, but the attorney who was trying to get out of it by saying somebody else reported, he wasn't entirely clean himself. He was going to get some money out of the not reporting, I think. So, okay. And without undue delay, this is the question of, okay, do you pick up the phone and call right away? Absolutely, except you have to consider your other ethical obligations, communications with clients, conflict of interest, and whether it affects your clients or another client of the lawyer's firm. So this one, it mentions comment 3. And all of those rules, 1.4, 1.7, 5.1 are mentioned in that comment. So, again, you think you're doing the right thing, you're doing it without undue delay, but oh my God, there's another hurdle to jump, and that's, does it affect the client's rights, other clients of the firm? So next. So where to report? The easy and obvious one is the state bar. There's an online complaint form. And I will tell you that I was looking around on the state bar today to see if I could find any statistics about reporting since August 1st. And I can't find anything, and we can talk about that in a minute. But I did see this online complaint form, relatively easy to use. If there's more than one attorney, you've got to use more than one form. But here's the kicker in California, and California is the only jurisdiction that allows this, is you can also report to a tribunal. And I think Sandy and I had some conversations about the potential misuse of 8.3, and we might have a little conversation at the end. And so, if you're in trial, you can potentially report to the trial judge if the opposing counsel is doing something that violates 8.3. And I think Sandy had some concerns about, whoa, are people going to use this for the wrong purpose? And the litigation has to be pending, and the tribunal has to have jurisdiction to investigate or act. I am pleased for myself, and I think for Sandy and Steve, that it cannot be a private arbitrator. So I think that really right there gives us some, if somebody reported to us, obviously we would have to help them report the right way, but we are not tribunals that can have the jurisdiction to investigate or act upon the misconduct. And then it references a rule of what are the tribunals. And obviously a superior court would be one such tribunal, but we'll get to the question of what happens if somebody misuses 8.3 to stall a case, right? So next slide. So this is the one, the abuse of 8.3. So attorneys are still prohibited from threatening to file a state bar complaint to gain an advantage, right? You can't call somebody up and have some kind of negotiation and say, well, by the way, unless you do what I say you need to do, I'm going to report you, right? You also, as an attorney, you cannot make a false or malicious report under the Business and Profession Code. You can't make any report to a tribunal and give testimony to a tribunal that is not truthful. And then you can't agree or seek an agreement that you won't report an attorney misconduct. And especially like what I mentioned in re Himmel, if there's a situation, well, if you give me part of the ill-gotten gains, I won't report you, right? And so this is the state bar's attempt to make sure that nobody weaponizes Rule 8.3. So it's going back to information that's already out there, Rule 3.1, and then the Business and Profession Code. And I think we're almost at the end of 8.3 here. So these are just the key points, what we talked about. You know, when you must report, when you may report, when you cannot report, what you have to report, what is a substantial question. And really, it's when it goes to the attorney's honesty, trustworthiness, or fitness as a lawyer in other respects. And only in California, you can report to a tribunal or you can report to the state bar. Sanford, Steve, I think we're done with 8.3.
Wow, that, you know, as I said, this is such a new area of concern for California attorneys. I'm glad that you covered it so well. And there's a lot of questions. I'm not sure how we're going to deal with the questions. Maybe Hayward can help us with that. But yeah, this is very interesting. So for example, there was also an issue about if there's another privilege that applies. So for example, the very first hypothetical with, was it Anne and Richard and the trust account issue? What if Anne and Richard are married and in a law partnership? What happens then?
Well, I think like it's been a long time since I've used spousal privilege and marital privilege, right? It depends on who holds the privilege. Can she waive it and still report? I don't think she can hide behind it, right?
Well, that's what I'm saying. There's all these questions. I don't know, you know?
Yeah.
Right. So I think a lot of stuff that you covered answered many of the questions, but you know, we can perhaps wait until the end of the presentation to get to them. It's all up to you.
I think we should, because both you and Sandy have quite a bit to say. I will try to look through them if I can and see if there's any that I can answer just during the presentation. But I really think that we need to let you move on a bit.
Okay.
Yeah.
Okay. Sounds good. Okay. So first of all, for those of you that have lasted all this long, since 9 o'clock, like David Hoffman said something in the chat about how he's been here since 9. I commend you and thank you for sticking with us. Let me move on to another subject now, which is mediation confidentiality. And I know Jeanne and Sandy, both of you and I all use what I call the mediator's spiel at the very beginning of every mediation, telling the participants what the mediation is going to be like, what it's all about, what our role in the mediation is as a mediator, and the very important topic of confidentiality in mediation. So we need to talk about where all of that comes from and what the purpose of it is. Well, we always talk about what the purpose is to have the participants share with us anything that they believe will help the settlement discussion in the mediation. Even if it's a privileged issue, if it's a very private issue, it helps to have the information out there so that we can get the parties to negotiate fairly and try to resolve the case short of having to go to a trial or an arbitration. Next slide, please. Okay, so what is the issue of confidentiality, or how does it come into the picture? It has different applications. One application obviously is through the evidence code, and that's the California evidence code starting from 1115 through 1129, but specifically 1119 talks about what is considered confidential and what does it mean to be confidential. So the very first thing that 1119 talks about, it says all communications and negotiations between the participants in the course of mediation are confidential and shall remain confidential. Well, what does that mean? So the next item in 1119 talks about how whatever comes out, whether it's a written document that's been created for the purpose of mediation, if it's some admission, if it is some discussion that may lead to having liability ruled against one party or damages or what have you, none of that is admissible. Nobody can try to bring that into the trial or arbitration of this conflict. So that's how it's kept out as confidential. That also goes to any, as I said, any writing. So any writing, any document, such as a mediation brief or any mediation letter, sometimes attorneys give me letters instead of briefs, that's been prepared for the mediation, for the purpose of mediation, or in the course of the mediation, it's not admissible, and nobody can compel disclosure of that document or discussion or admission in a trial or a adjudication venue. So that's how confidentiality is enforced. Next slide, please. So those were the California State Code applications for the confidentiality, Evidence Code 1115 through 1129. The federal courts also have their own rules. Federal Rule of Evidence 408 also prohibits bringing in anything that's been said or prepared as part of a mediation into the trial of the case. So it talks about what's not admissible. So again, it's the admissibility that is the gateway to hold back anything that was confidential as part of the mediation. And so the very first thing that it talks about is if there's been any offer or promise to perhaps pay something and resolve the case from one party to the other, or any other conduct that's been made during the negotiations and a mediation process. Now, you'll see that a lot of these eventually will have their own exceptions, and we'll talk about some of those exceptions. Next slide, please. Okay. The other aspect of confidentiality, which is not necessarily codified, is the procedural aspect of this. Now, I don't know who still conducts joint sessions in California. I don't think Jeanne, Sandy, do you guys do joint sessions? Yeah, nobody does that anymore because
Fairly. It depends on the case.
I'm sorry, Sandy?
Depends on the case. If the parties tell me that it will serve, or if I get a sense during the proceeding of the mediation that I believe it will serve, then I'll initiate it. But generally, my practice is not to use it unless I think that it will serve or the parties request it.
Makes a lot of sense. Did you want to add anything, Jeanne?
No, I'm
No,
fine,
okay.
thanks.
Yeah, I don't as a matter of practice, or as long as I've conducted mediations, I have not had joint sessions. And so that's another layer of confidentiality, that what is coming out in these separate caucuses will remain confidential. And so there are different approaches to that as well. So for example, you can say, well, all information shared is open to disclosure to all parties. And you better let everybody know that that's the case. Or you can say only information that's been given by one party in one caucus to the mediator can be disclosed to the other side. Or you can say only the ones that you tell me not to share with the other side, I will keep confidential. Now, I'm sure each of us have our own habits and uses of this multi-layer approach to keeping information private versus confidentiality. I guess it's a matter of semantics, but this could be called private versus confidential, whichever way you want to call it. My practice is that I will let the participants know that because of the confidentiality rule that the evidence code provides, I will share everything with everybody else unless they tell me not to. So I guess I fall into that third category here, and I ask them, or I tell them, that if there is some information that you specifically don't want me to share with the other side, please tell me right now so that I can make a note of it and make sure that I don't mention it in the other caucus. So those are the different approaches. And again, we're talking about how to maintain confidentiality and maintain private information as between the parties. Next slide, please.
Just a second, Steve.
Sure.
For people, I just listened to the approach that you have. For people that are listening to this, I think one of the golden nuggets you could take away is when you start your mediation, or before you start your mediation, you want to ask your mediator what are their ground rules, because you don't want to make an assumption. When I do a mediation, I remind everybody of the confidentiality provisions, and I tell everybody that I consider that everything that they tell me is confidential, and I will only disclose what they give me authority to disclose. But as an attorney, I've been whipsawed by mediators who were working, with the idea that they'll disclose everything, but they never told me that. So for anybody that's out there, any attorney that's out there, don't make an assumption. Find out from your mediator what the ground rules are that they work with, so you don't get the floor pulled out from under you.
Sounds great, Sandy. And that's beautiful. That specifically walks us into this next slide, which is right here. And that's California Rule of Court 3.85. No, let's keep that previous slide, please, if we can. There we go. Thank you. And that's specifically what you were saying, Sandy. So excellent point. So California Rule of Court 3.854D specifically speaks to that. And it says that the mediator must first discuss with all participants his or her practice regarding confidentiality for separate communications. So that's specifically what you were saying, and I'm glad you brought that up because it just basically walked us into that slide. Now, this may be a good point for us to take a break, because people have been, sitting here for about more than 15 minutes. So maybe we could take a short break. Hayward?
That sounds fantastic, Steve. Thank you. So it is 4:53 right now. How about we take a quick 5-minute break? We'll come back at, because we're into the third minute, 4:59. Does that sound okay with everybody?
Sounds good.
Sounds great.
Fantastic.
It's a lot of interesting questions there.
Yeah, and I think the 8.3 thing, yeah.
There's some great questions, such as
What
about reporting a judge? And, there's that first question there about the three.
I noticed a couple of questions in the Q&A about this confidentiality issue. One had to do with the issue of what do you do when a mediator ends up sharing confidential information that you told them not to share with the other side. Good question. That is absolutely not a very good problem to have, for sure. What do you think, Jeanne, Sandy? What do you think the steps to be taken in that situation are?
Where a mediator shares information that he was advised not to share.
Exactly.
Mediator again. Okay, that goes actually to the theme of what I'm going to talk about. You have to use.
All right. So we'll hold off on that. And then there's another question about, third parties that are not participating in the mediation, and we'll get to that too. If you look at the evidence code, it talks about this confidentiality or inadmissibility of information that was generated or prepared in the course of mediation or a mediation consultation. So what is that? What is that course, and when is that over? So there's a couple of areas where, more than a couple, you can see it on the screen, where that comes up. Well, first of all, if everybody signs a written settlement agreement that fully resolves the dispute, then the mediation is over, the course of mediation is over, and there's no more issue of confidentiality after that. And then there's an oral agreement between the parties that fully resolves the dispute. However, that oral agreement has to be in accordance with Section 1118, which is actually rather onerous. It requires that it be presented before a court, that it be recorded, and eventually signed. So it says it's an oral agreement, but it also eventually ends up being something that documented. So that's one thing to keep in mind as far as oral agreements are concerned. Or the mediator provides the participants with something in writing that says, as far as I'm concerned, this mediation is terminated, or words to that effect. So that also terminates the quote unquote the course of mediation or a mediation consultation. And all of these, again, they affect the confidentiality issue, the admissibility issue. And then there's those situations where some parties resolve their case and some parties don't. And so some parties continue mediating and some parties don't. So as to those that don't and terminate the mediation, obviously the mediation is terminated and the confidentiality issue also goes away as far as what happens after that. There's also this timing issue. If for 10 calendar days, there is no communication between the mediator and any of the parties to the mediation, the confidentiality, that course of mediation ends. So then anything after that is not confidential. My practice in this kind of a situation is that if a case does not settle in mediation and I need to follow up and continue following up with the parties, I have them waive that requirement or that 10-day cutoff time so that we can continue to discuss the case and try to negotiate without the fear of the confidentiality having been waived. So that's my approach. I don't know what you guys do, Jeanne.
That's a great approach. I've also clearly put on an email, like if I'm going to be calling or speaking with somebody, this is a continuation of the mediation. But I like your approach. I like that everybody waives it all at the same time.
Right. Okay.
My practice is if the case doesn't settle, I follow up until the case either settles with me or without me. That's my practice. I don't stop.
What do you do about the 10-day thing?
I keep on going,
Okay.
I just keep on going. But, I think it's a good idea probably to send an email or something saying I'm going to keep on going. And your participation is a waiver of Evidence Code 1125.
Right. Okay, great. So there are different approaches, but everybody is aware of this 10 calendar day cutoff time. And obviously there's this one exception. It's not an exception, but it just says that this whole section doesn't preclude a party from ending a mediation without reaching an agreement whenever they feel like they're not getting anywhere with it. So it doesn't take away any rights of any party to cut off the mediation. Next slide, please. So one of the questions of the Q&A was, what about non-parties? And that, again, the California Rule of Court 3.854D says a mediator must not use information that has been acquired in confidence in a mediation outside of the mediation for anything else or for anybody else or with anybody else. That is not completely satisfactory, I think, as an answer to a question like that, because this only talks about a a mediator. What about if somebody else learns something who's a third party completely unrelated to the case, but that could use that in some other form or fashion for their own benefit? And I'm not sure what the answer to that is. Do you guys know what the answer to that is?
I guess I'm trying to figure out who you might be suggesting as the third party.
Yeah, that's a good question. I don't know. I guess it could be anybody that's outside of this dispute that's being mediated and somehow learns about some confidential information in the course of that mediation, or somehow gets that information from someplace. I think the question is, I think the answer to that is really, it all depends. I mean, who is it? How was it acquired? And what purpose would they want to be used it for? So yeah, I don't know if there's really a straight answer to a question like that until it's really, really clear what we are talking about.
Right. I'm thinking of like maybe a significant other coming as
I
a
was just,
support
right.
and then learning something. And so I'm very careful when there's third parties that they are clearly just support, and I do not have any conversations in front of them. So it's not, to me, I try to make sure that they don't learn it through the mediation. If they learn it through their, the plaintiff or the defendant, that's on the plaintiff or the defendant. That's not necessarily on me, right? But you obviously do everything you can to prevent that as well.
I think that where this rule may come into play is, with remote mediations, where there may be other people overhearing things that they shouldn't be hearing. The context that it comes to me in is some sort of business or securities related mediation, where perhaps there's going to be a public offer or some sort of something where some third party can gain financially or gain a benefit by access to confidential information. Excuse me.
That's very good. Thank you. Now, here's an interesting case that somewhat may relate to what we were talking about, and that's Cassell versus Superior Court, where the Supreme Court of California ruled that the mediation confidentiality from one case applies to a subsequent case where there was an issue of legal malpractice against the attorney who had handled the previous case. And the Supreme Court said the confidentiality from that previous case, from that previous mediation, applies to the next case as well. So you cannot use what was learned in that mediation in the previous case in the next case where the client is suing the attorney for malpractice. This is a very important case. We should also be very careful. We don't have it here on the slides necessarily, but different jurisdictions, different states deal differently with this. So it becomes important if you're dealing with a multi-state or a state outside of California, you're dealing with a case that deals with different jurisdictions. They may deal with this differently. Here, we're just talking about California, obviously, but just be careful about the issue of confidentiality when you're dealing with other states. Other states may not have these protections for admissions and discussions in mediation. Now, perhaps because of this Cassell versus Superior Court, there was a discussion in the legislature about, allowing the use of confidential information from a mediation to be used by a client who's suing that attorney for malpractice. It went back and forth and it didn't go anywhere. But what they did pass was that they said, they added Evidence Code 1129, which requires attorneys to have their clients sign off on this acknowledgement of mediation before they go into a mediation. It basically talks about the issue of confidentiality and so on and so forth in that notice. So that's at least where they got to. And there's a very specific language that the code provides. And there's a form now that I'm sure everybody's familiar with that every attorney has to have his or her client sign off on before they go into a mediation. Next slide, please. There's also, in addition to the evidence code and then the federal rules of evidence and the court rules that we talked about, there's the Uniform Mediation Act that many states have adopted. A lot of it is the same as what's in the California Evidence Code, so it doesn't really make sense to go through that because it's already codified in California for the most part, not all of it, obviously. And the reason I have this confidentiality / privilege is that the UMA calls it a privilege, not a confidentiality thing. He just calls it a privilege. So that's why I had that in here in case you run into it at one point or another. Next slide. Thank you. Here are the exceptions to confidentiality. So it's not completely bulletproof. There are ways that whatever has happened in mediation may still come out. Number one is everybody signs a document or an agreement in writing that communication or document or whatever it was that came out in mediation can be shared and is no longer confidential. It can come out as a non-confidential item. Well, that's clear. Everybody has agreed to it. And then the next one is where there is, again, as I was saying, there were, different parties that do reach a settlement and those that don't. So those that do, prepare a document that says, okay, we are agreeing to not hold this thing as a confidential item anymore. And then the third one is what we were talking about, which is Evidence Code 1129 and this new rule with this new notice and acknowledgement to the client about mediation. And that is when the bar has to do an investigation on an attorney to see whether they had complied with that requirement or not. So these are the various exceptions to mediation, confidentiality, and there are more. Perhaps on the next slide, we can talk about it. So again, we talk about admissibility or inadmissibility as the way of enforcing the confidentiality issue. Criminal proceedings are clearly out of this. So if there's something that is going on that ends up in some criminal proceeding, the information that was obtained in the course of a mediation, of a civil mediation, can be brought into the criminal case. So be very careful about that. Potentially, it could also be used for impeachment. I haven't really seen many cases or instances where that has happened. So for example, in a mediation, somebody makes an admission, but then the case doesn't settle and goes to trial. And in trial, the person makes a totally opposite statement. That could perhaps be used to impeach that witness. Again, it may be. So keep that in mind. It's a may. And warning with a, red warning, I should say. Be very careful because when we talk about inadmissibility or that it's confidential, if the information is subject to discovery and there is time to conduct discovery, that doesn't stop the other side from actually sending a discovery request, such as a deposition notice or document request, interrogatory, something to that effect, to get to the bottom of that confidential, quote unquote, confidential information that was shared in the mediation. So if your mediation is being conducted at a time that still leaves a lot of time for discovery to be conducted, be careful about that. Next slide, please. Okay, so these are the exceptions to the confidentiality under the Uniform Mediation Act. Again, a lot of them are very similar to what we have in California, but there are some different ones. Like, for example, I'm just going to go to the very last one, to the right-hand side, bottom right-hand side. That is kind of interesting to me. It says, if the evidence is not otherwise available and there is a need for that evidence that substantially outweighs the interest in protecting the confidentiality, then you could perhaps see the confidentiality waived or gone away with. And also keeps talking about, you know, a felony or misdemeanor proceeding, which is criminal, and to prove a claim, to rescind or reform or a defense to the liability that came out of the mediation. So again, I don't want to go through every single one of them, I'll bore everybody, but UMA also provides certain exceptions to this issue of confidentiality. So what needs to be kept in mind, I think, really, instead of just reading every one of these things, is that confidentiality is not bulletproof. There are ways that confidentiality can be waived or done away with. So keep that in mind. I don't know if there's another slide on the confidentiality, because we're getting close to a time when we should have a break. What is the next slide, Hayward? I'm so sorry. All right. So the one important thing to know is that this entire chapter about confidentiality in mediation does not apply to settlement conferences pursuant to Rule 3.1380 of the California Rules of Court. So again, keep that in mind, that in settlement conferences, you do not have the type of confidentiality protection that we've been talking about here under the evidence code. Okay, so maybe we should take a break now and get ready for Sandy?
No breaks necessary, Steve. I think we just jump right in with Sandy.
Okay, great. Thank you.
Okay, we ready to go? Okay, good afternoon, everybody. For those of you who've been listening to this presentation from the beginning or looking at 28-line paper all day, thank you for your patience. In the words of, to paraphrase Saturday Night Live characters, I'm here to spark you up, okay? We're going to talk about ethics in mediation. Are there ethics in mediation? What happens when an attorney tells the mediator that they've got a great witness who's going to kill the other side's case, but they don't really? Okay. What happens when the attorney tells the mediator, my client will only take, or my client will only pay X amount? Are there ethical issues here? Let's get into it. First of all, my job is to help you have a more successful mediation. Okay. My other goal is to help you obtain a mediation where your client, whether a plaintiff or defendant, gets the best possible result, and you get the most out of the mediator and the mediation process. You may have heard, some of you may have heard the story about the teacher who says, the question isn't what you've come to me to learn. The question is, what attitude have you come here to learn with? And the same thing could be said about mediation. What do you expect of a mediation, and what do you expect of the mediator? And what framework are you going to when going to? Not long ago, I had a retired judge who works for a prominent mediation service say to me, I work in a business where people lie to me all day long. What's that all about, and how does that affect ethics as far as ethics in mediation goes? What you need to be able to do to have a successful mediation, to advocate for your client, whether you're representing a plaintiff or a defendant, is you need to be able to give a mediator all of the critical information. I'm going to give you a 10-point program at the end of this, which if you go through, you know, you're all going to do great jobs. You need to hire a mediator you can trust. We heard a little bit earlier somebody saying, what happens when a mediator discloses confidential information? That's not what a mediator should be doing. That's not a mediator you want to use again. That is a no-no. You want to hire a mediator you can trust. We all know that a certain part of mediation is a charade. Everybody knows it. Plaintiffs commence with larger numbers, defendants offer smaller numbers, and in the end, most mediations end at around a third to a half of what the plaintiff initially demanded. Everybody knows this is the way that the game to a certain degree is played. But how about looking at it from a different framework? You have to ask yourself, do you look at a mediator as an adversary, or do you look at a mediator as someone you can trust who will help you to accomplish a resolution of the case that's within the framework that your client anticipates and hopes to have? That's the mediator that you want. So how do you get the best possible results without violating any ethical rules? What's the difference between lying and puffery? I'm going to tell you all about it. Okay, first of all, every attorney should take a look at State Bar Opinion Number 2015-194, which presents an issue when an attorney is engaged in negotiations on behalf of a client. What ethical limitations are there on statements made by the attorney to the mediator and to third parties, and what's considered puffing, what's considered lying? So let's talk about what the difference is. And the way we're going to do that is I'm going to give you a bunch of examples. For example, the first example that I mentioned earlier, you've got a mediation going on, and one of the attorneys says to the mediator, I've got a witness that's going to kill the other side's case. I've got a witness statement that's going to wipe out their case. But it's not true, okay? The lawyer is just saying this to make the mediator, to diminish the value of the case in the mediator's mind, and to diminish the value of the case in the opponent's mind. Can you do that? Is that an okay thing to do? Absolutely not, because it's a lie. You can't lie, okay? And when you do lie, you could get in trouble for lying, because there are rules of professional conduct that say we as lawyers cannot lie, okay? So you can't do that. This is, to put it in lawyer language, this is a material misrepresentation intended to be relied upon by third parties. In my language, it's a no-no. You can't do it, okay? Let's talk about another example. Lawyer, this may happen with plaintiffs' lawyers. Lawyer says, my client's lost earnings are $75,000 when they're only 50. Lawyer may say, my client's meds are X when they're only Y, okay? Or when the Howell numbers are Y. Can you do this? Absolutely not. If it's not true, you can't do it. And if you do it, it's an ethical violation. And if you commit an ethical violation, you could be in trouble, all right? You can't do those things. Basically, the guide is you got to tell the truth, all right? But what's the difference between lying and puffery? Here's another example, and there's case law on this. And I've seen this happen in cases of my own when I was working as a plaintiff's attorney. Defense counsel says policy limits are 50 grand when they're really $1 million, okay? Because they sort of forgot that umbrella there, okay? I've had that happen. You can't do that, all right? And there's case law where attorneys have been sanctioned for doing that. You can't do that, all right? Again, that's a lie. That's not puffery, all right? Another example. What about a case where lawyer says to mediator, my client won't take less than, or conversely, my client won't pay more than X? Is this a lie or is this puffery? Anybody want to take a guess here? Anybody
I'd
want
say
to
it's
say
puffery.
anything? Okay. Mr. Sepassi says puffery. Okay. Anybody else want to offer an opinion here?
Well, I'm the only other one that gets to speak up, but I think it's also puffery because
Okay.
I think there's a case on that.
Okay, that is puffery. Look, we've all done it. Every attorney before they became a mediator has said those words. And as mediators, we've all had those words said to us. That is puffery. Lawyers, you can do that. It's okay. But this goes to my theme earlier of what do you bring to the mediation? How do you look at your mediator? You need to have somebody you can trust. All right. Here's an example. Let's say you're a defense attorney and you've got sub rosa evidence. Okay. But you don't want the plaintiff to know, but you want to get that case settled. You need to be able to have a mediator that you could trust, that you could say, look, I've got sub rosa evidence. It's going to kill this plaintiff's case, but we're going to offer 10 grand. We're going to offer 5 grand. We're going to offer cost of defense. You know, if the case settles today so that we save money, okay, you need to have a mediator who can go to the other side and say, I can't tell you why, but you should settle this case. And this is a good number. And if you're a plaintiff's attorney who's hired a mediator you can trust, you will listen. What happens when you don't listen in a case like this? Here's a case that I really had as a plaintiff's attorney. I had 2 defendants. It was a case of a woman pulling out of a garage where there was a hedge. So there was a premises owner, and there was the operator of the car. Both defendant attorneys came to me and said, look, we can't tell you why, but we're going to offer you this de minimis money, 5, 10, whatever it was. You should settle this case. Well, of course, you know, I made a recommendation to my client whose significant other worked at Rand. He wasn't a lawyer, but he was a better lawyer than me, even though he wasn't a lawyer at all. They hired another plaintiff's attorney. The plaintiff's attorney tried the case. The plaintiff was on the stand testifying about all the things she couldn't do as a result of that car accident. And then the defendant's attorney said, Your Honor, can we dim the lights? And they played the video. And there she was jogging out on the beach in Santa Monica. The verdict came in, defense verdict. The defense went in for their costs, and the plaintiff wound up filing for bankruptcy. This was not a good result all around. Okay, you need to have a mediator you can trust who can communicate these things. Okay, let me give you some other examples. Here's one we've all heard. Defense attorney says, you know, if they don't take X, my client's going to file for bankruptcy. Puffery or a lie? Anybody want to take a guess?
I'm sorry, Sandy. Can you tell me quickly what that was again? I missed it. I'm sorry.
Okay. We've all had this. Plaintiff's attorneys have had this a lot. Okay. Defense attorney says, if they don't take what we're offering today, client is going to file for bankruptcy. On the part of the attorney saying it, is it puffery or is that unethical? Is that a lie?
I think that one depends. I
was
think
just-
that if it's completely made up for purposes of, you know, trying to scare, then it's a lie. But if it's a potential that's been discussed with the BK attorney that, you know, your client has actually told you, laid it out, this is what could happen and this is what I'm anticipating, I think you can use it. But I think good counsel will also say, you know, qualify it to a certain extent, right?
It all depends upon the capacity of the client you're representing. So if the lawyer knows that the client is going to and is capable of declaring bankruptcy, then it's puffery and it's okay to say. If the lawyer is saying it, but knows that there's no way that the client, you know, could possibly file for bankruptcy given their financial situation or given the circumstances of the case, or because the case involves some sort of intentional tort or, you know, drunk driving or something like that, that the client can't file for bankruptcy, that's a lie. Again, that's unethical. So lawyers out there, don't do it. You'll get into trouble. Here's another example. Typically, this comes from the plaintiff's side. Plaintiff's lawyer says, my client can never work again. We've got a loss of earning capacity. But the client has told him he's got a job lined up. And after the case settles, he's going to work. What then? Puffery or a lie?
That's a lie.
Okay, it's a lie, but the problem is it's an attorney-client communication, so that's a problematic kind of situation, which puts the attorney in a conflict, and ultimately what the attorney has to do, if they're going to do the right thing, which is a tough thing to do, if you've got a big case and a substantial settlement there, and you're working typically on contingency, the attorney has to sub out. Okay, very tough position to be in if you're that plaintiff's attorney. Going, on the theme of attorney-client communications, let me go to something else here. This case kind of blew me away. Attorney represents to mediator. It's okay. I've got the authority to settle. My client trusts me. Okay. This happens sometimes in remote mediations where the client isn't available. For those of you attorneys out there that are listening to this, you've got to be really careful about this. Okay. And you need to be aware, just as there's a case that I told you about where defense attorneys misrepresented insurance proceeds, policy limits, types of things. Okay, there's a case on this. It's a relatively new case, 2021. I'm going to pronounce it the best I can. Amjadiv, AMJADIV versus Brown, 68 Caleb 5th, 383. Okay, here are the facts of the case, and probably every plaintiff's attorney has been involved in this case. Client's in a car accident. Everything's going well. Case is set for trial. Until a week before trial, attorney-client relations break down, and client fires attorney and hires new attorney. New attorney goes to trial, tries to continue the case, and we've got a hard blank judge who won't continue the case. And judge says, case is going to trial, all right? And new attorney then tries to sub out, the day before the trial is going to go, and judge denies it. And, new attorney's in a pickle. So what does the new attorney do? New attorney goes to defense attorney and says, hey, is there any way we could settle this case? And defense attorney says, well, yeah, if you'll take $150,000. And new attorney, it's not a small sum of money. And new attorney says, I don't want to try new attorney doesn't say, but says to himself, I'm not prepared. I'm not ready. I don't want to try the case. I never really wanted to try the case. Yeah, we'll take the $150,000. My client's given me authority because I've got a retainer that says, client agrees that if settlement offers tendered in the case by any defendant, and the attorney believes in good faith that the settlement offer is reasonable, and that acceptance of the offer is in the client's best interest and should be accepted, client authorizes attorney to accept said offer on client's behalf at attorney's sole discretion. So attorney says, I've got it in the bag. I've got it in my pocket. I've got this retainer signed by the client. I'm taking the $150,000. I never really wanted to settle the case anyway. And authorizes judge to dismiss the case. Well, the Court of Appeals said in 2021, that's a no-no. Can't do that. You have to act in your client's best interests. And by the way, there's a new rule of professional conduct that says you have to communicate settlement offers to your client, even if it's oral. It used to be that you had to communicate a settlement offer to your client if it's in writing. Okay, so plaintiffs would make their policy limit demands, in writing and communicate to the client what the settlement offer was. Plaintiffs would do 998s and send that to the client in order to inform the client, or if they got a 998 from the defense. Now, for you lawyers out there, if you don't want to get in trouble, if you get an oral offer to settle the case, put it in writing and send it to your client. My recommendation is when you're in mediation, when you get that offer that your client's going to accept, send it to your client by email and have your client acknowledge it. So you're not in trouble and the client can't say later, I didn't authorize that, bring up this case, you lose your fee, and you're involved in some litigation. You want to protect yourself. So again, you cannot say to the mediator, you've got authority when you don't, and don't have this kind of clause in your retainer because it'll make your retainer voidable. Okay, as far as that rule of professional conduct, 1.4, and let's see, it's 1.4.1, which says you've got to communicate oral settlement offers. Can I see? Okay, this is a slide I wanted to see. So let me give you what I recommend is the 10 rules in mediation that will enable you to have a great mediation without violating any ethical rules. Now, these things seem obvious, but as a mediator, I cannot tell you how many times I've had mediations with people represent both plaintiff and defense counsel who have not checked these boxes. All right. Number one, know your case. Know the risks. Know the value of the case. Number two, know the injuries and know the damages. If you're on the defense side of the case, know the medicine. Okay. Oftentimes I get plaintiff's counsel who send me confidential briefs. Why? Okay. Remember, you're asking somebody to give you money. You have to understand the dynamics. There's a defense attorney there that's going to make a recommendation to an adjuster. There's a supervisor looking over that adjuster's shoulder who's going to say, why did you authorize this settlement? There's somebody possibly an adjuster, believe it or not, sitting over the shoulder of a long experienced attorney. It used to be that attorneys had the authority, defense attorneys had the authority to settle cases. Now you've got a dynamic where you've got adjusters with a year's experience telling defense attorneys with 30 years experience what to do. Plaintiff's attorneys, you need to understand the dynamic. Give the defense every reason why they should pay your client money. Don't keep it a secret. Sometimes there are misunderstandings. You may have a premises liability case where the defense thinks that your client had a sprained ankle when they had a broken ankle. Okay. Forget about confidential briefs if you're the plaintiff's attorney. It won't help you. Defense attorneys, if you've got a mediator you can trust and you've got information there that you want the mediator to know to be able to throw cold water on the plaintiff and accomplish a settlement, they need to know. The mediator needs to know. Again, it's all about having a mediator you can trust who's not going to disclose confidential information and pull the floor out from the plaintiff's case or the defendant's case if the case does not settle. That mediator doesn't help you. Next thing, know the medical bills and know the anticipated reductions. Recently, I was talking to a friend of mine, a very prestigious plaintiff's attorney, who happens to have a brother who's a prestigious defense attorney. So my friend said to me, I've got a case with $1 million in meds. And his brother said to him, well, what are the Howell numbers? And the defense and my friend said 300 grand. And his brother said, you don't have a case with $1 million in meds. You need to be realistic. Okay. You need to know lawyers on both sides of the aisle. You need to know these numbers so that you can communicate with the mediator if you want to have an effective mediation that gets your case settled. Okay. Next thing, from both the plaintiff's side and the defendant's side. What's the old saying? The defense attorney always knows more about the plaintiff than the plaintiff's lawyer. I found that to be true at times. Okay. You've got to know the pre-existing condition of the plaintiff. I was once in an arbitration back when arbitrations were popular, when the defense attorney kept asking my client, is this your only accident? Is this your only accident? And then he reached into those black, ugly cases that lawyers used to carry. Some of you may remember them. And he pulled out a stack of records 2 feet tall and started going my client's previous accidents. I called a break, took my client out on the street, gave him a little street justice and said, you need to tell me the truth. And we're going to go back in here. Okay. So if you're the plaintiff's attorney, You need to know your client's medical history. If you're the defense attorney, you need to know the plaintiff's medical history, and you need to let the mediator know you know it. And that's why you're making the evaluation that you're making. Okay, next thing, plaintiff's attorneys. You need to understand the defenses here. A good lawyer sees a case from 360. A good lawyer sees a case from his client's perspective and from the other side's perspective. I always thought it was a great mediator's tool to say to a defense counsel, what's a plaintiff's best case? And vice versa. Okay? You need to know the other side's case and what the defenses are or what the strong points are in the case. And not all of that is in the case. Okay? You may have a plaintiff with a great case who makes a terrible presentation. You may have a plaintiff with a pretty good case who makes a great presentation. This may not be on the 28-line paper, but you need to know these things. Okay? There are other cases. You may have a delicate case. This may be a sexual molestation case or a sexual harassment case with a sensitive adult client or a child, okay, where one side or the other wants to say, my client doesn't want to try this case at the end of the day. I've had peeping Tom cases where the defense attorney has said, the last thing my client wants is to try this case because his wife doesn't know about it. His wife doesn't know that he had a camera in the public bathroom in their rental property and that he's going to have to pay all this money. You need to know these things. You need to communicate these things to the mediator because these are all part of the dynamics that enables an honest mechanic mediator to get the case settled. So you need to know these things and you need to share these things. And if you have a mediator that you can't share these things with, that's the wrong mediator for you. Okay, next thing. Seems pretty obvious, but like, us mediators can tell some tales. You need to know the law. You need to know the law, whether you're a plaintiff's attorney or a defense attorney. You need to know the law. I'll get to civility in a second. Okay. Another thing, it's not what's on the 28-line paper. It's whose name is on the 28-line paper. Okay. Who's the plaintiff's attorney? Does this person have a record of trying cases where basically from the defense side, you're mitigating risk because they got the money, the know-how, the confidence, and the track record, and they don't care. Okay. They know how to try a case. Okay. Or is this somebody else? And also from the defense side. Okay. Do you have a client who's willing to basically say, not a dime for tribute, and everything for defense? You need to know your adversaries. Okay. Or do you have, is there one side or the other where they maybe never tried a case? Okay. All of this affects the value of the case. You need to know these things. Okay. Last thing, historical settlement range. How many cases, how many mediators can say that a plaintiff's attorney's come to them and said, I don't know, what do you think I should ask for? What do you think it's worth? Okay. I mean, there was a plaintiff's attorney that came to me who became a mediator. And he said, now that I'm a mediator, every client, every attorney comes to me and goes, what do you think this case is worth? Okay. And the answer is whatever they'll pay. Okay. However, there's data out there. The Daily Journal has verdicts and settlements. Lexis has settlement information. Find out, your case at Vaughn's where somebody slipped and fell and had a broken ankle is not the first one, unless she's a ballerina, or Britney Spears, can't get out and dance or something. Okay. There's historical value. I'll just give a quick anecdote. I was arbitrating a case and the arbitrator told me, I just settled the case for a whole lot of money. The meds were $150. Okay. Case settled for $1 million. I'm sitting back there as a young attorney going, how did that happen? Okay. How does somebody with $150 bill settle for $1 million? Well, here's the answer. Guy's going down Santa Monica Boulevard, gets in an accident, hurts his hand, goes to Cedars. Okay. Problem with hand. Lead guitarist in a famous rock and roll band had a 1-week contract to play in Japan. LOE, $1 million. Okay. You need to know these things about your case. Okay. Last thing. If your case can't settle, everybody think outside the box. Stop using mediators just in the way that you've learned or the framework that you've gotten used to. Use your mediators to help settle procedural issues, discovery issues. It's a continuing relationship until that case is settled, signed, sealed, and in the box or on the disc or wherever it goes, where it's going to, going to the end of the road. Okay. So this is what I have to say. I'll just emphasize again, use a mediator you could trust. The civility in mediation. Plaintiffs, with honey, you get money. Okay. I can't tell you how many mediations I've done where I've had an adjuster say to me, I've got more money to offer, but that guy was just so the plaintiff's lawyer was so uncool. They were rude, they were hostile, they were this, they were that. In 41 plus years of practice, what I found is, okay, our profession, there's echoitis, okay, and I'm going to tell you what I mean. And it's not repeating something in a brief. What is said here is going to be heard over there. The way you treat people is going to come back to you. Experienced attorneys who try a lot of cases, plaintiff and defendant, they don't have to rattle their sword because they're walking quietly and carrying that big stick. And that big stick is their reputation. All right? Treat people nice. You will always get a better result, whether you're on the plaintiff side or the defendant's side, and certainly from the mediator. A mediator will not respect someone who's dishonest with them. And that echoitis is going to come into play because we all know we're experienced people. We're old enough to know a little bit about human nature. People talk. People talk. Judges talk. Judges go into that lunchroom. They can't associate with attorneys. They live in a certain isolated environment. And I know this because I was twice appointed as a referee. Okay. Judges talk. They talk to their colleagues. And if a lawyer is rude, if a lawyer is dishonest, you better believe they tell the other judges. And when that person winds up in that judge's courtroom, the recipient who hears, that judge is going to be on, have his guard up or her guard up. Okay. Be nice. You will get a better result. Does anybody have any questions? Does anybody have any comments, love letters, or advice?
Okay. Thank you so much, Sandy. That was very engaging. Thank you very much. In fact, you can tell from some of the questions and comments that are being written in the Q&A that, everybody's really enjoying your examples and your presentation. Thank you. Okay. We don't have a lot of time left. We actually really went through the time kind of heavily. So I wanted to talk about procedure. I'm sorry, Sandy, go ahead.
I was going to say, look, everybody, can we go through these things like with, quick 1-minute answers and hit on each one? And because everybody, was kind enough to take the time to respond and they need to know. So can we do that? I don't personally care if we go a little overtime, but everybody else, of course.
It's up to you if you can go through the Q&A and see something that you want to answer right now.
You can type back answers to some of them. And maybe we can get through some of the slides and then hopefully we'll have a little bit more time at the end to answer those that we can't just type, right?
Sure. Okay, so I'll make this one kind of quick because again, we don't have a lot of time left. And that is, when you're in a mediation, what is procedural fairness versus outcome fairness? We all think of this idea that a mediator should come up with a solution that is fair to everybody. And that is not exactly what the rules of court say. So, for example, let me quickly bring up an example. This was actually a scenario that was raised by a very well-known mediator. And, you know, everybody has got their own, I guess, solutions to this. So let me give you the scenario. You find out from the defense that the defense is willing to pay X amount of dollars to get rid of this case. The plaintiff tells you that they are willing to take X minus a certain amount of money to settle the case. So, you know, at first look, you're like, okay, the case is settled, but now you've got some discrepancy as to what the figure for the settlement is going to be. So as an example, let me just put some numbers out there so it's very clear. Somehow you find out that the defense is willing to go up to $100,000 to settle the case. Plaintiff shares with you in confidence that they'd be willing to take $90,000 to settle the case. What do you do with that as a mediator? Jeanne, Sandy?
I was typing an answer to a question.
Oh, sorry about that.
I was
Sorry.
doing the same.
Okay, so let me quickly repeat. It's very quick. So that somehow you learned from the defense in caucus that they are willing to go up to $100,000 to settle the case. The plaintiff lets you know that they are willing to go up to $90,000 to settle the case. So now you've got a $10,000 discrepancy, extra money someplace. What do you do with that situation as a mediator?
I think you find a compromise solution that makes everybody happy. Okay. Somewhere within that range. I don't, you know, and if everybody's happy, I think that that's a good solution. You know,
Okay.
I mean, I'll put it in a different context. You know, a certain number of hostages are being held. One party says we'll release X number. You know, the other party says we want X number. Somewhere in the middle. I mean, you know, somewhere in the, you know, whether more hostages are released and one party wants to release, or, you know, whatever it is, these are lives saved. And if everybody is okay with it, then that's okay.
Okay. All right. So I think that's goes back to this issue of what is our job as a mediator? Are we there to make sure that the solution is substantively fair, or are we there to make sure that the procedure is fair? And that's what this topic is about. And the rules of court, believe it or not, talk about procedural fairness, not substantive fairness. So our job as mediators is to make sure that the mediation is conducted in a manner that complies with voluntary participation, meaning that people are there on their own volition. They haven't been coerced, they haven't been pushed, they haven't been extorted or anything to that effect, that they have voluntarily chosen to be there in that mediation to resolve the case. And it also talks about self-determination by the parties. And so as reference, this is California Rules of Court Rule 3.853. So when you look at those two things, there's nothing there that talks about substantive fairness. It just talks about procedural fairness. So again, because of the shortage of time, I'm not going to bother to read what's there as far as what it's meant by procedural fairness. But you can just quickly read through those if you wish. So let's go to the next slide. So what is procedural fairness that the rule of court talks about? This is Rule 3.857. It says that the mediation should be conducted by a mediator in a procedurally fair manner. Again, that goes back to this issue of are we supposed to come up with a fair outcome? And that's not what the rules of court say. In fact, as I've highlighted in the slide, it says a mediator is not obligated to ensure the substantive fairness of an agreement reached by the parties. So interesting, isn't it? We all come from the angle as mediators that we want to be the voice of reason. We want to be the peacemaker. We want to be the, as I call myself, the village elder, and make sure that everything is fair to everybody, that the outcome, the result, the solution, the settlement is fair to everybody. But that's not what the rules of court ask us to do. Next one, please. Okay, so what a mediator is supposed to do is to explain the process to everybody and make sure they understand the process. That's really what a mediator is supposed to do at the beginning of each mediation, to tell them that they're there voluntarily, that they can end the mediation at any time they want, and that and what the procedure is going to be used. So for example, in my mediation, I always explain at the beginning to the participants that because of the separate private rooms, I'll be going through what I call the shuttle diplomacy, that I'll go into one room and discuss the case with them, and I'll come back to this room and discuss the case, and I go back and forth. So basically, I try to explain the procedure to them. Next, please. So again, as part of the presentation or part of the explanations to the participants by a mediator, in trying to make sure that the procedure is fair to everybody, the rules ask a mediator to tell everyone that we're not there as their lawyer. We're not going to do anything other than being an impartial participant in the process, an impartial mediator. We're not there. And again, as part of my spiel to the participants in a mediation, I always tell them, I'm not here to pass judgment. I'm not here to rule on anything. I'm not a judge. I'm not an arbitrator. I'm just an impartial mediator trying to see if I can help the parties negotiate a settlement out of the case. Next one, please. And this is, again, as part of the explanation to the parties and making sure that the procedure is handled properly. Now, what is interesting here is that if you read this slide, it talks about how a mediator can terminate a mediation or withdraw if there are certain circumstances. So, for example, if it's being used, if the mediation is being used to further illegal conduct, or a participant is unable to participate meaningfully in the negotiations, or continuation of the process would cause significant harm to any participant or a third party. So these last two, are broad enough that may not just necessarily apply to somebody who may be sick or just not able to continue, but also maybe somebody who's just not equally able to negotiate for himself or herself. Maybe there is another stronger attorney on the other side, and this participant on this one side is just not able to counter that strength and power. So I don't know. It sounds like, that is also something that even though they tell us that we're not there to make sure that the matter is substantively fair, it does kind of lead itself to that angle, reading this 3.857. I don't know if there's another slide for me, but we are also running out of time.
Yeah, so it's obvious to me, or apparent to me, that there's a lot to talk about and about this, but unfortunately we have run out of time, so I'm going to have to conclude this. So that's it. Thank you again for everybody joining us today.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.